Good evening and welcome to the Select Board meeting for February 2nd, 2021. This is a program called Working with 40B, and joining the board today are Johanna Schneider from Hemingway and Barnes and also Judy Barrett of Barrett Planning Group, and they will be leading us through this. I would like the members of the board to please identify themselves. That's part of the practice now that we're able to meet remotely during the pandemic. So I'm Melinda Collins, I'm chair. I'm Katie.
Katie Conlon, vice chair and member.
Arthur. We'll go to Mike Zulis.
Mike Zulis, member of the board.
Thank you, Mike. Richard.
Good evening, Madam Chair. Richard Wells, member of the board.
Thank you. And Arthur. Well, I did see you here earlier, so thank you. And I will now turn it over to Johanna and Judy. Welcome and thank you for having this session for us.
Thank you. I think the purpose of this session, is every member of the board is aware. The town has recently had sort of an onslaught of a number of 40B projects. 40B is very different from typical project review. And I think that it tends to, when towns are not terribly experienced working with 40B, it tends to spawn a bunch of different questions about different elements of the town's roles and responsibilities, what the framework looks like, and how the process goes generally. I think ideally we would have done this training preemptively, when we knew everything was coming in, but I think, we're going to file this under better late than never. And we're going to just walk through, the things that we think that the select board should know about how the process goes. And also, the members of the public who are interested in the process might have this also as a resource to better understand the regulatory, legal, and procedural framework that the town, and in particular the ZBA, is operating under when we've got these 40B projects. Judy, do you want to add anything before we kick off the presentation?
Oh, I think that was perfect. Shall I go ahead and start the screen share?
Let's do it.
Okay. Let's see. I'm not sure this is going to allow me. Oh, there we go. There we go. So once I go to full screen on this, I won't be able to see anybody. So Johanna, if you see an eager member of the select board who's dying to ask a question or something, can you just jump in and let me know, because you're more likely to see them than I will.
I will absolutely do that. And I think we can do this in a couple of different ways. Members of the board, if you have a completely pressing question, or something is confusing as we go, certainly let us know. We've got a lot of material to cover. And so it may make sense for, sort of more general questions to get to the end of the presentation and do any questions then if there are things that we haven't answered. But I think if there are things that are unclear or confusing along the way, definitely feel free to stop us and we can answer on the fly.
Okay.
Is that okay?
Okay. Super. Okay, so not surprisingly, the title of the slide deck is Working with the Massachusetts Affordable Housing Law. And there is sort of a structure to what we're going to do. I want to introduce a little bit about the statute and some of the background. There are some things about this law that people don't often know, and your select board may know, but if not, I just want to go through a few basics. We're going to get into a fair amount of the weeds with how the process works from the initial project eligibility phase, which you folks have all been through and I think are still going through. And then how things work with the Board of Appeals. And after the Board of Appeals has finished its process, what sort of takes place. People sometimes forget that there's a whole ensuing bureaucracy that occurs when the Board of Appeals grants a comprehensive permit or denies it, as the case may be. And then we thought it would be good to do a little bit of an overview about some of what's been happening with fair housing in Massachusetts, because Chapter 40B, the Affordable Housing Law, and the Federal Fair Housing Act are in some ways inextricably tied together. So there are some things happening at the policy level with the state that might be helpful to you to understand from a fair housing perspective. So one of the things I think that's important to know about Chapter 40B is that it's not just an affordable housing law. It's actually the Commonwealth's regional planning statute. So in the early 1960s, the legislature, like as many other states did, adopted Chapter 40B to establish regional planning agencies. So entities like the Metropolitan Area Planning Council, which includes Milton, was formed as a result of that statute. Toward the end of the 1960s, a period that actually I'm old enough to kind of remember, the legislature amended the regional planning law to add the sections that we now typically call Chapter 40B. And those sections are the affordable housing law. And it's in the regional planning statute for a reason, because the law was intended and is intended to address regional housing disparities. So although a lot of what we're going to talk about tonight is in one way or another connected to the 10% standard that I think all of you are familiar with at this point, and when communities prepare their housing plans or thinking about local needs, that's all very important. But the statutory framework is about regional need. And when the Board of Appeals gets to the point that they have to make a decision about any matter that's in front of them under this law, the balancing test is local concerns balanced against regional housing need. So it's important to understand this is in the regional planning statute for a reason. It assumes that a community has met its fair share of the regional housing need if at least 10% of the units in your community are affordable to people who are low or moderate income and subsidized by a federal or state program, which we'll talk a little bit more about what subsidy means as we go on here. But that's the basic framework of the affordable housing law. It's that it intends to address regional housing disparities, and you're presumed to have met your fair share if at least 10% of the housing in your community is affordable to people who are low or moderate income. So what the Regional Fair Share Report Card kind of looks like, we just pulled some data together from the Department of Housing and Community Development. This is current information. I actually just got this today. Looking at Milton and some of the communities around you. Of course, we didn't include Boston in this because it really wouldn't make much sense. But we looked at the other communities, and as you can see, the ones that are identified in capital letters here are all over 10% at this point. And they got there through various means. Will they stay at 10% once the Census 2020 housing counts come out? That's a good question. We don't know. But right now, they're there. And Quincy, which I thought was actually over 10%, is not quite, but close. Norwood, quite close, but not quite. So basically, you have some neighbors that are just almost at 10% and several that are over 10%, and you folks are under 5%. So those of you who might have attended a meeting for the East Milton planning process way months ago, when I put a map up of Milton and the surrounding towns that just sort of showed where all the multifamily housing activity was taking place at the time. And there was Milton with nothing, with no dots, on any addresses. And I said, where do you think you are? And what do you think is happening? So really, this is kind of a regional framework. It's a regional context. And I think it informs kind of the number of 40B applications that you've seen lately. There's just a lot of activity happening in your part of the state because people are looking for multifamily opportunities and especially rental opportunities. So again, I don't think it's much of a surprise that a lot of the development you're seeing is attempting to address the demand for rental housing.
And we'll get to this in just a minute, but one thing I did want to flag about these numbers in the communities around you is that, and again, we're about to get to this. Once a community is over 10%, the dynamic for permitting a project under 40B changes significantly. And so as you look at your neighbors who are just at 10% or just over 10%, 40B development becomes a lot less desirable in those communities. And so you may find more people looking to Milton because it is under the 10%.
Right. So although we typically talk about the 10% threshold, and that is the most common metric under Chapter 40B, the statute actually talks about 3 ways that a community could have been deemed to have met its regional fair share. Stated another way, 3 ways in which a Board of Appeals could deny a comprehensive permit and have that decision essentially upheld or not overturned by the State Housing Appeals Committee. And so one is if you're over 10%. So, if you are under 10%, you're presumed to not have met your regional fair share. Or if the town, even if it's at less than 10% in terms of affordable housing, but if the land in your town, if at least 1.5% of the land area in your community is occupied by lower moderate income housing, even if the units in those developments don't add up to 10%, if you were over that 1.5% standard, the Board of Appeals again could deny a comprehensive permit and not have that decision overturned by the Housing Appeals Committee. And I think, as you folks know, the town asserted that a few years ago, and DHCD determined that you hadn't met that standard. But that's another provision of the law. And then there's this third provision that says if you're getting a project that's significant in size and is likely to disturb more than 0.3% of the land area in your town for construction of affordable housing, then the Board of Appeals could turn that project down and be deemed to be consistent with local needs. So one of these standards is about units. One is about the overall amount of development in your community that is comprised of lower moderate income housing. And the third standard is one shot, one project of significant scale that likely would overwhelm the community. So those are the 3 standards that are recognized in the statute. We call those the statutory minimum. So when you're under the 10%, and obviously this applies to the 1.5% standard as well. It's just a little easier to talk about this in terms of the units. If you're under 10%, developers applying for a comprehensive permit are kind of presumed to be eligible for waivers of local regulations. It doesn't mean the ZBA has to grant them all. It doesn't mean that the developers are going to get all of them, but there's a presumption in the statute that they are eligible for those waivers because your town hasn't met your regional fair share. So along comes a developer who says, I want to build affordable housing in your community. You haven't met your fair share. So I'm going to ask for waivers of your local regulations. And the law assumes that I'm kind of eligible for those. So we're going to have a conversation about that as the permitting process goes forward. The ZBA's jurisdiction is narrowly defined when you're under 10% as being focused on what the statute calls a series of local concerns, which I'll talk about more in a bit. They're actually pretty common sense standards, to be truthful with you. They are not much different from any other permitting process, but the statute is very focused on this is the box within which the ZBA can make a decision, and a lot of other things that you might be able to consider if it were a special permit or a variance or something else. You really can't go there when it's 40B. And then, of course, if you're below 10%, when the ZBA gets to the point that it has to make a decision, that standard is balancing the regional need for affordable housing against local concerns. And the law kind of assumes, because it wants to see affordable housing built, that the regional need is paramount. That doesn't mean the ZBA has to grant every comprehensive permit that comes before it. It just means that you've really got to have a basis to say no, and you need to be thinking about the impact of the conditions you place on the project if it's going to make the project uneconomic to build.
And I think the other thing that you need to think about is because appeals of ZBA decisions by the applicant at least go to the Housing Appeals Committee, they take a very narrow view of what the permissible local concerns are. So when you're looking at the local concerns, there are even things in the statute and in the regulations that as a practical matter, when the HAC goes to review a ZBA decision, it may decide that the language of the statute and the regulations may say this, but these are not really local concerns, and they're certainly not ones that outweigh the regional need for affordable housing.
Yeah, the regional need is a very high bar. So when you're above 10%, developers applying for comprehensive permits, may need waivers. They can ask for them, but they're not automatically eligible for them. And we do have towns in Massachusetts that are over the 10% threshold, and developers continue to develop under Chapter 40B there. And the towns continue to grant comprehensive permits. So there's nothing that says the ZBA can't grant one. It's just that the balance of power, if you will, shifts. The ZBA's jurisdiction, because it's still a 40B permit, is still kind of defined by those local concerns, but you know, it can kind of require more compliance with local regulations within the context of those local concerns than it probably could if you were under the 10% threshold. And then just generally, once you've hit that 10% or you're over it, you have more control over future development because the developers cannot appeal to the Housing Appeals Committee. And that's really what the standard is. It's in the end, it's can the developer go to the Housing Appeals Committee or not? So when a community is under 10%, I'm sorry, go ahead, Joanna.
Yeah, and I was just going to say, you know, the advantage to the town, and obviously Milton's got some ways to go before getting there, but the real advantage to taking in 40B projects when you're above the 10% is that, and I'm not sure if we mentioned this, but you know, the 10% is recalculated with the census every 10 years.
Right.
And so, you know, there might be some reason why you want to make sure that you are continuing to keep some degree of affordable housing production up, even if you've hit your 10%. But because the balance of power has shifted, as Judy said, the town has a lot more ability to control what the projects look like. And there may be some projects that have an affordable component to it that would, you know, count towards the subsidized housing inventory. But, you know, you can do a deal with the developer where the town feels like this is a really good project and you don't have to, you're not limited in the same way as you are when you're below the 10%. So you really do have an opportunity to do a little bit more planning and to work with developers who are not using 40B to kind of force a project, because they can if you're under the 10%, but it's a lot more of a cooperative effort once you're above that 10%.
Yeah, I recently worked with Natick probably 2 years ago, which is over 10%. And they intentionally permitted another Chapter 40B development, basically to buy some insurance so that when the 2020 housing counts come out, they won't be under 10%. And Amherst has recently done the same thing. So, you know, it is out there, but it does reset. And we're all waiting to see when the Census 2020 housing counts are going to come out. Of course, that doesn't mean that the subsidized housing inventory automatically resets. The Department of Housing and Community Development still has to go through a whole set of calculations, but it will come eventually. So thank you for bringing that up. So back in 2000, this is a great story. Back in 2000, we were having a surge in housing activity. I don't know how many of you are old enough to remember the recession of the late 1980s. I am. But for several years, housing development just came to a screeching halt in Massachusetts. And so a lot of towns that were already over 10% in 1990 kind of stayed there because not much was happening. But then around 1997, the market started to pick up again. And there was more activity in housing development, and we started to see more Chapter 40B applications. A significant uptick, as a matter of fact. Well, that coincided with the Census 2000 housing counts, and a number of communities fell below 10%. Added to that sort of dynamic was that the Housing Appeals Committee had recently issued a decision that many consider path-breaking, in which they opened the door for a new type of housing subsidy that previously had not been recognized, called the New England Fund. And so when you added that to this now uptick in housing activity and the Census 2000 numbers coming out, a lot of communities fell significantly below 10%, and a war ensued. And so in an effort to try to essentially rescue Chapter 40B from being overturned in the legislature, the Department of Housing and Community Development came out with a new set of regulations that created this concept of a safe harbor rule. And what the safe harbors work as is, if you meet one of these, if one of these applies in your case, then your Board of Appeals could turn down a comprehensive permit if it wished, and its position relative to the Housing Appeals Committee would be the same as if you were over 10%. So let me just explain what this means. One of the regulations, and you guys are familiar with this at this point in Milton, is that if you have a housing production plan, as you recently completed one, and it's approved, And then you produce new housing under that plan in a sufficient quantity that your plan can now be certified. So you go back to DHCD and say, we've actually produced housing this year. We've produced enough to meet our goal. And DHCD says, you absolutely did. So we're going to certify your plan. You may, in fact, be eligible for a 1 or 2 year period, depending on the number of new units you've created, that your Board of Appeals would not have to approve a comprehensive permit, and the developer would not be able to appeal to the Housing Appeals Committee. So the Housing Production Plan was an effort by the state to say, we know you don't like Chapter 40B, but if you work with us on this and you actually produce more units, we're going to give you credit. So it became a way to kind of slow down the pace of comprehensive permit activity. There's another standard called recent lease in progress rule, which is even if you don't have a housing plan, but you produce a certain number of units, which arguably it's a higher number. So the housing plan is kind of an incentive. But if you hit another target, you may be eligible for at least a 1 year reprieve from seeing additional Chapter 40B activity. The regulations also provide for a size limit so that, especially for smaller towns, this was really more relevant in those cases than perhaps yours, but there is a cap on the size of a 40B project that can come before the Board of Appeals, which if it exceeded that, the ZBA would be able to turn it down and the developer could not go to the Housing Appeals Committee. And then finally, there's this concept of the related application. A developer comes forth with, say, an application for a special permit under your existing zoning. The planning board turns them down and they say, I'm going to go get a 40B. So the regulations provide that, no, wait a minute, you can't do that right away. You have to at least have a 1 year cooling off period. So these so-called safe harbors were written into the regulations in 2001 and 2002 in order to give communities some incentive to create housing at a pace that they could manage. And those rules were updated somewhat in 2008, but this goes back 20 years. Essentially this idea that if you do certain things as a community, maybe you're not at 10%, but we'll give you a break, is essentially the way to think about those safe harbor provisions. Johanna, did you want to add anything to that?
No, I think that covers that.
Okay. So I think you probably all know this, but just to make sure everybody understands, I get this question all the time. Well, what do we mean by affordable housing? It's housing in the context of the Massachusetts Affordable Housing Law. We're talking about housing, first of all, that counts toward the 10%. It's housing that is affordable to people whose incomes are at or below 80% of the median for your area, which is the Boston metro region. Those income limits are determined by HUD. And this is essentially what we're looking at for the income limits today. These are generally updated March, April, somewhere in there. We should see new income limits in the next few months. But this is essentially what it looks like. And the reason there are 3 tiers here is that these income limits are all tied to the regulations that apply to the Section 8 program. And so the Section 8 program has these tiers of income limits that I don't need to explain all this today, but just suffice it to say that if a Chapter 40B development has 25% of their units affordable to low-income households, so say for that, a household of one, it's $67,000, or 20% of the units affordable to a household at 50% of AMI, so a household and one-person household with income at or below 44.8, either one of those cases qualifies that rental project for a comprehensive permit. So it's either 25% for households at 80% of median or 20% of the housing units affordable for people at 50% of median.
And so, one thing I wanted to highlight is that a criticism that many affordable housing advocates have of 40B is that in order to qualify for 40B, you only have to have 20 or 25% of your units as affordable. The rest can be market rate units and typically are market rate units.
Right.
But the advantage to the town is that the entire number of units will count toward the SHI number. Even
Right.
if you are only providing 20 or 25% affordability, the whole project gets to count.
Right. So we're going to talk process now, and we're going to get into project eligibility, which is something I think you all have experienced quite a bit of in the last several months. That's actually how I first met you, Mike, was over a project eligibility application. It's an application to a subsidizing agency. In most cases, that agency is mass housing. Sometimes it is mass housing partnership. Once in a great while, it might be mass development. But most of the project eligibility applications we see go to mass housing because frankly, they have the broadest repertoire of programs. When that application goes to the subsidizing agency, the local officials are notified, as you know, and there is a site visit, or supposed to be. I realize the pandemic has kind of disturbed some of that, but the regulations call for a site visit of some type, and a review process moves forward. Within mass housing, that involves verifying the land value, so there's an appraisal that's commissioned. There are standards of review, which I'll get into on the next slide. It's important for people to understand, and I think they often don't, but the housing subsidizing agency is not a permitting authority. And they will actively resist being put in that role. The project eligibility decision they grant, if they grant it, in most cases they do. It's essentially opening the door, or if they deny it, it's closing the door for the developer to go to the ZBA. If there's no project eligibility letter, there's no application to the ZBA. It's really that simple. So it is a very important step, but it's not a permitting decision. The permitting is entirely in the jurisdiction of the ZBA. There is nobody else who has jurisdiction over a comprehensive permit once it is applied for. So the subsidizing agency has to look at 7 factors, and they're all in the regulations. I could summarize these rather than reading them all to you by simply saying the question for the subsidizing agency is simply this: if the Board of Appeals granted the permit for this project, would we approve it? Would we, when the applicant comes back to us for a subsidy decision, for regulatory agreement, for all the things that the subsidizing agency has to do in the end, would they fund that project? That's what really these standards add up to. And I know that it causes a considerable amount of frustration at the local level. I think that communities often don't understand why mass housing or MHP doesn't just say no to a project that people may consider to be a bad project. But from a housing subsidizing agency, I think there are 2 points to consider, maybe 3. One is that they're operating from the perspective of wanting to see affordable housing built. That is their framework. The second consideration is that they're thinking about a project where would we approve this if the local officials approved it. So we're not going to step in the shoes of the local officials and view this project for wetlands because the Conservation Commission is going to do that. We're not going to view it for zoning because the Board of Appeals is going to do that. I mean, there are boards at the local level that are going to act on this. And really what we are is an agency that's either going to open the door or not. That is the framework.
And I would just add, even though these are criteria that are listed in the regulations that the subsidizing agency will consider, ultimately, there are 3 main legal requirements for eligibility. One is that the applicant is a qualifying entity. So it has to be either a public agency, a nonprofit, or a limited dividend organization. The second is that the project is fundable or financeable under their underwriting criteria. And that's what a lot of these things on this list on this slide go to. Is it a fundable project? And then the third thing is, does the applicant control the site? So again, that's a legal question. Do they have fee ownership of the site? Do they have the site under agreement such that they can make decisions about its future land use? Right. Ultimately, at the end of the day, it's just 3 criteria, and that's all that the subsidizing agency is entitled to look at under the statute and regulations. Yep, that's well said. That is really what it comes down to. And those items, that whole framework is in the statute, and essentially what the regulations do is empower the subsidizing agency to determine whether the applicant meets those standards. Are you eligible? Do you have site control? Is this a fundable project? So there are local responsibilities, just as the subsidizing agencies have responsibilities. One is, if you can, to join the site visit so you can see what's going on.
the select board has a unique role as the elected officials, the chief elected officials in the community, because you're the ones who will be notified about the project eligibility application, and you're the ones that Mass Housing wants to hear from. So it kind of puts you in the driver's seat in terms of organizing a comment process that will ensure that the town's perspective is represented to Mass Housing. That means making sure that your town departments weigh in from a technical perspective if there are particular things they're concerned about. Boards that would typically have permitting jurisdiction of some type, or even just a review role, even if they weren't actually issuing a permit, but boards and commissions and departments that sort of can act from a technical perspective and look at the project and provide comments to you, focusing to the extent possible on the project eligibility, regulatory standards, and those local concerns that the statute recognizes. So if you kind of frame your comments around what the subsidizing agency actually can even consider, it's more likely that even if they're issuing the PEL, project eligibility letter, there'll be some recognition of what the town's concerns are, as opposed to simply dismissing them outright. And ultimately, your role then becomes transmitting those comments to the subsidizing agency by the deadline that you are given.
Right, and typically that deadline it's a 30-day review.
Typically.
And that's, we've gotten this question from some of you in the past, what is the select board's role? This slide sums it up. This is your statutory regulatory role under 40B. It's the site visit, and it is rounding up comments from town departments, boards, and your own experience, and putting together a comment letter that then goes to the subsidizing agency. And that's the end of your designated role under the process, as it's set out in the statute and regulations. One other thing that I did want to make clear is that, you send the comment letter in, Mass Housing or whatever the other subsidizing agency may be is looking at it. They will issue, assuming that they find that the project meets the statutory criteria, they will issue the letter. There is no right to appeal the issuance of a preliminary eligibility letter. Once it's out and the project is ready to move forward.
Right. So the good news for you, I suppose, is that once that's over, you could have nothing more to do with the 40B process if you chose. Now, at this point, it is entirely with the Board of Appeals, and I want to talk about how that process works. Johanna already talked about this. I'm just going to briefly point out that when the application comes in, be conscious whether it's rental or ownership, because the number of units that will count if the project is approved, the number of units is very different. In rental developments that qualify, all the units will count. In a homeownership unit, the affordable units count. The developer's the one deciding what he or she is applying for. So it's not as though the developer can come in with a homeownership project and the town can say, well, we want to do this as a rental development because all the units will count. That's not the town's call, it's the developer's call. And it's really pretty much handled at the project eligibility phase anyway. So the Board of Appeals has pretty broad scope under the Affordable Housing Law. It's everything that is a local regulation. So that's zoning, it's subdivision control, it's if you have a local wetlands bylaw or local septic system regulations, that gets subsumed by the comprehensive permit process, a local historic district, a scenic roads bylaw. The board has authority to grant waivers under any of these local provisions to allow the construction of affordable housing. Of course, if there are wetlands involved, the Conservation Commission retains its jurisdiction under the state wetlands law, Chapter 131, Section 40. So the Conservation Commission isn't out of the picture. But if they were accustomed to reviewing projects under both a local wetlands bylaw and the state act, their jurisdiction in these cases is limited to the state act. That said, I typically encourage conservation commissions to provide feedback or comments to the Board of Appeals because they'd be very helpful to the board in thinking about waivers an applicant may be requesting under a local wetlands bylaw.
And depending on the size of the project and its impacts, another state regulatory structure that is not waivable under 40B is the MEPA process.
Right. Good point. Thank you. I should have added that to that slide.
Next time.
There are a lot of things that are not within the board's purview, of course, one of which is impact on municipal and school facilities, that anything that's sort of available to all residents of the community. So, Mike, I remember we talked about this back at the project eligibility phase. There are just things that just are not appropriate to bring up with these developments. So the board can't consider fiscal impact, can't consider how many kids are going to go to the schools. Of course, if there's an infrastructure impact directly tied to the project, then that may be a matter that's appropriate before the board. But a facility that's generally open to the entire public, no. Another thing that the board doesn't control is how tenants or home buyers are selected. That's all sort of handled by the subsidizing agency in accordance with affirmative fair housing marketing guidelines that DHCD has for Chapter 40B developments. Monitoring of economics, the financial profitability of a project is handled by the subsidizing agency. The town is certainly entitled to see at the end of a project what the developer claims has been the profit of a particular development, but determining whether the project generated excess profit is up to the subsidizing agency. Another thing that the board really can't look at is a market study. Sometimes people will say, how do you know that that's going to work in our market area? It's the subsidizing agency that really has jurisdiction to decide, is this actually going to be marketable in this area? And I can tell you on a couple of projects I've been involved with working for ZBAs in other towns, that issue has come up after the comprehensive permit process, whether there was really a sufficient market demand for a certain type of housing. So once in a while, this does get questioned, but not at the ZBA level. As Johanna said, there are these three key things that subsidizing agency will sort of take care of this in project eligibility. Are you an eligible applicant? Do you have site control? Do you have evidence of project eligibility from the subsidizing agency? If these things aren't true, the applicant should not be in front of the Board of Appeals. The applicant has certain things that must be submitted to the board. These are all kind of laid out in state regulations. Some boards of appeal have regulations that ask for a bit more, and within reason, you can ask for a bit more. But what you need to understand is that the comprehensive permit process, because it's intended to be streamlined, is not going to provide a plan at the level of detail that one might expect to see with, say, site plan approval. It might get there, and some applicants do go that far, but it's not required. So the applicant has to provide a preliminary plan, a scaled plan of what this project's going to be. There needs to be an existing sort of site conditions assessment and a locus map, just basic things. Where is this project? What's on the site now? How are you proposing to lay out the development you're planning to build on this site? What will your buildings look like? Give us a sense of the exterior, the massing, what the architecture is going to be, floor plans, so that we have a sense of what these units are going to be. If the project involves a subdivision, which isn't that common, but when it happens, the applicant also has to provide a preliminary subdivision plan. And this is sort of something that often gets kind of confusing to communities. A lot of towns in Eastern Massachusetts just don't even see subdivisions anymore, but typically that is handled by the planning board. But if there's a subdivision involved with the 40B, it's the Board of Appeals that acts in the place of the planning board. There has to be a preliminary utilities plan. How are you bringing water and so forth into this site? And then, critically, the list of waivers. And this is where the applicant says, I've got a project for you. And the subsidizing agency's approved it. And I want to build this development, but I can't do it if I have to comply with all your rules and regulations. So these are things that I need you, the ZBA, to waive so I can build my project. So it has to be a list of waivers. My experience is that list changes as the course of the permitting process unfolds, because there are changes to the plans pretty much all the way through. It is an iterative kind of permitting process. And so what may have been the waiver list at the outset often changes by the time we get closer to the end of the permitting phase. This is a chart that I know you probably can't read, but it's this is my I go everywhere with this chart, and we lay this out so that towns understand when they have to do certain things. One of the saddest experiences I ever had with a ZBA involved the town of Walpole a few years ago when they requested a consultant from Mass Housing Partnership, and I was assigned to go and work with them, and it was Christmas time. And so no one really looked at the application and no one actually noticed when the developer had applied. And I didn't see the materials until it was too late. But in fact, the town didn't understand that they had to open the hearing within 30 days. So this lovely woman who worked for the Board of Appeals thought it was the typical standard for opening a hearing for any other project and scheduled a hearing within 65 days, which is the typical standard for a special permit or a variance. And the developer just quietly waited until day 31 and then filed with the Housing Appeals Committee for constructive approval. So we always start out with making sure that towns understand this really was intended to be an expedited process. So you have to pay careful attention to timelines. So the hearing has to open within 30 days. Under the statute, when the board's hearing ends, the decision has to be filed with the town clerk within 40 days. Much of what else is in this chart is actually a function of regulation. And some of it just applies if the town, for example, thinks it's already at 10% when the developer applies. There's a process you have to go through to notify the developer. We think we can turn you down because we need a safe harbor or we're over 10%. And the developer has the opportunity to rebut that. And if the parties can't agree, then DHCD steps in and becomes the arbiter of a dispute. So while all of that's going on, this 180-day clock that's ticking for the hearing is kind of put on hold. But the intent of the regulations is to say, ZBA, you got 180 days between the beginning of this hearing and the end of it to conduct business. Of course, naturally, if you get to 170 days and there are still some issues to work out, typically developers will agree to a modest extension. But the goal is to get it done. So 180 days is kind of this, it's sort of a mission that's assigned to the ZBA to conclude the permitting process within that period. A public hearing it can be a challenge because many of these developments, stir up people. Their developments are typically very different from what folks are typically are accustomed to seeing in their neighborhoods. And so there's a natural tendency for people to get pretty energized about a Chapter 40B application. What I can tell you is that for the board to have a decision in the end that's defensible, the process really from the outset has to be sort of focused on fairness to everybody. It has to be thorough review. And the hearing process needs to be evidence-based. So you have to kind of always be thinking about, I know I have an angry neighborhood or I have an angry whatever, but what are the facts in this case? And this is where I think the help of peer review consultants, which I'll talk about more in a little bit, is just so critical to the board. Having those independent assessments of kind of what's fact here can be extremely helpful to the board in reaching a fair and defensible decision. The actual hearing process should not be much different from the way a special permit or a variance works. There's an application, the applicant presents, the Board of Appeals asks questions, abutters and other interested parties can comment. It's in that respect, it's really not much different. And in fact, you have to be careful not to treat 40B projects differently from the way you treat other developments. So there's that kind of balance of fairness as well. The statute's pretty clear about this. You can't ask a 40B developer to do something that someone else is not asked to do. So things like excessive application fees and so forth are just not allowed. Town departments have a technical review role. Planning, conservation, health. I know Tim is working on kind of organizing all of this and frankly doing a wonderful job at it. The board needs to hear from the department heads as to the technical matters with the project that those departments would normally be involved with. What does the water department say? What does DPW say? What's the stormwater issue look like? Focusing on the technical role of those departments. Police department and fire look at it from a public safety perspective, and their input is critical, not only just in terms of access to the site, but also even internal circulation on the site. Can a fire truck actually circulate the building? Can it get 3/4 access around the site? I mean, it's just really important stuff that they play a role in.
Yeah,
The ZBA also, go ahead. I'm sorry,
sorry.
Johanna.
I was just going to chime in about, the way I always view the ZBA and a 40B is it sort of acts as a super board, right? It takes the jurisdiction of every other board in the town who in a different type of regulatory framework would have, their own jurisdiction and their own review process. And all of that falls to the ZBA. And, it's the zoning board. They are
Right.
zoning people. They are not public works folks. They're not Board of Health folks. They don't know about police and fire. So it really is critically important that they do get feedback from all of the different town departments and boards. Because without that information, it's very difficult for them to make an appropriate decision. They're really just guessing because these are things outside of their area of expertise.
Right. So getting that help is important. And in addition, having the assistance of peer review consultants. So as I think some of you may know, we went through a process to engage peer review consultants for traffic, for site civil engineering, and for design. Those people are now, I'm happy to say, all under contract. So they will be starting to do their reviews and advise the board accordingly. And of course, other interested parties may bring consultants in as well, which is important. But ultimately, for the Board of Appeals, the board needs its consultants, and that's the function of the peer review folks.
Right. And I think it's important to keep in mind that those retained peer reviewers are the board's consultants.
Right.
In my own experience, sitting on a ZBA, I have had fellow board members who didn't quite understand that the reason that we had the peer reviewers was to help us and
Right.
help, give us information and perspective that we would not ordinarily have. Peer reviewers are not meant to be advocating for anything one way or
Right.
the other. They're not there for ZBA members to, for example, cross-examine. They really are there as a resource, an additional resource to provide assistance, backup, and support to the board members.
Right. They can be the appropriate filter too for, well, the applicant's engineer said X, but you need to think about it this way, or the engineer that was hired by an abutter or some other interested party. People are they have an advocacy perspective, but the peer review consultants have advocacy perspective is for the board. It's how do I help the Board of Appeals make the best decision that it can.
That's very well put.
How can all of you help? I think this has come up a lot, at least in my experience, since the board started hearing the 40B cases that are currently in front of the town. Keeping the focus on technical issues that fall within the board's purview will be one of the most helpful things I think anybody can do with all of these 40Bs. Making sure that claims, assertions, and so forth are documented. What is the documentation? Where's the evidence? Town departments may be called upon, some department heads, I'm not sure, it's too early to tell, but may be asked from time to time to participate in a work session with the developer. Sometimes work sessions are very helpful. It's not intended to substitute for the public hearing. It is not in any way changing the Board of Appeals jurisdiction, but sometimes it's just helpful to work out details of things that are purely technical and frankly would be kind of boring in the middle of a public hearing process in what we call a work session. If there are work sessions, whatever comes out of it goes back to the Board of Appeals in the form of a recommendation. They get to decide whether they want to accept or reject the recommendations that come out of a work session process. So the authority of the Board of Appeals is never changed, even if there's a discussion with the developer around a table in the planning department or the public works department. Those are technical conversations only. And then also providing timely public information, because naturally abutters and others want to know what's going on. And so the effort that's been made to kind of clean up the Board of Appeals 40B page and get information in an easily obtainable form is really a great start. Most communities I work with do that. They just put everything on the website so that when an interested neighbor wants to know where things are, they can find it easily. And it certainly is also a help to the peer review consultants, I might add. The board can hire peer review consultants at the applicant's expense. The purpose of the peer review consultant is to review whatever the developer has submitted. It's not to provide independent studies that the board may want to conduct. If that's the case, that's the town's expense, not the applicant's. Any reports that are provided by the peer review consultants go in the record. And of course, they can be reviewed by the developer who may or may not like them, by abutters who may or may not like them, but it's all part of the record. What the ZBA kind of needs to do and is doing, I think, at this point is trying to focus on what are the real issues with these projects? What kind of impacts are we most concerned about so we can focus in on things that really need attention, because some things that come up are not as important as others. So getting a handle on what the real issues are with these projects as soon as possible is really key. The board should always feel that it has the right to ask for additional information from an applicant if something isn't clear. Often boards will need more help to kind of visualize what something's going to look like. So, asking for graphics that help to clarify massing and setbacks and so forth. Those are all valid things for the board to request. And in this day and age with SketchUp and so forth, it's really very easy for an applicant to provide a 3D model for the board to be able to visualize what a project is going to be like. So the board needs to have permission, give itself permission to ask those questions. And I'm sure your board will. The whole issue with the waivers really comes down to, do you need them? Do you actually need the waivers to build the project? And so often what happens in these processes is that you get to a point where the board kind of knows what it would like the applicant to do, and the applicant is not happy about it, and they either work it out or they don't. And if the board is asking the applicant to make some changes that the applicant says, I cannot do that, I won't be able to build my project. Only at that point can the ZBA say, fine, we're going to do an independent financial look at this project. So the other peer reviews are all done. The developers had a chance to change their proposal, to respond to whatever the peer review reports say. The board has kind of looked at that and started to talk about what conditions they might put on the project. And the applicant says, I can't do that. Simply can't do that. That's when the ZBA can hire a peer review consultant to review the pro forma for the project. What the applicant has to provide the board is a pro forma for like what they've asked for, their original proposal, and then a pro forma that says, and if you make me do this, this is what the impact's going to be. And of course, naturally, what the developer is going to submit will typically show that it's going to make the project not financeable. The board is entitled to have someone give an independent look at that and say, is the developer right or not? My experience, for whatever it's worth, is that if you can avoid this, it's probably a good idea. Johanna and I've had discussions about this with her colleagues in Brookline as well. The problem is if the peer review consultant comes back and says, you know what, the developer's right, you've kind of lost your leverage. So, you try, the point of this whole process is to get the best project you can for your town. If you cannot work it out between the board and the applicant, it's going to get to this point of a financial peer review and let the chips fall where they may. But I think that it's definitely not something that you can start out coming out of the gate. The regulations simply don't allow it. The board has to give the applicant a chance to modify the proposal, and the applicant has to be given a chance to push back. And if they just can't reach agreement, then a pro forma peer review will need to be done.
I want to add a couple of things about
Sure.
the pro forma review. I mean, I think the biggest risk, as Judy said, is that you go to pro forma review and your peer reviewer who's doing the pro forma review says, yeah, you're right, it's uneconomic, right? So if the ZBA still decides to plow ahead with the conditions that make the project uneconomic, you have basically handed the developer a perfect appeal to the Housing Appeals Committee. Because what the Housing Appeals Committee is looking at is whether or not the conditions imposed on a project by a board make the project more uneconomic or significantly more uneconomic than the project that was proposed in the first place. So if you go through pro forma review and you find out that what you're doing does make the project uneconomic, you have basically guaranteed that you lose on appeal to the HAC. The other thing that I do want to flag, there is something in the 40B regulations that expressly prohibits a town from conducting a pro forma review in order to drive a reduction in the number of proposed units. It has to be something, if you're looking for a reduction, for example, it has to be directly related to a valid health, public safety, environmental design, planning, other local concerns. Oh, here are the local concerns.
That's right.
That you're allowed to look at. It can't just be a reduction for the sake of a reduction. And that's explicit in the regulations.
Yes. So yes, voila, here are the local concerns that the statute recognizes. Funny about that. So this is sort of, these are the criteria that the ZBA can weigh against that regional housing need. Public health, is there a public health impact of this project that cannot be mitigated? Is there a public safety impact that cannot be mitigated? With any kind of redesign or any other change, can't be fixed. Is there an environmental impact that simply can't be mitigated? Design. This is why I always, on any multifamily application, always encourage my boards, get an architect to assist with peer review. Many towns don't have any design review process whatsoever, and this is alien to them. And they don't even understand that they have the right to do design review. So it is in fact a recognized consideration. It doesn't say density, it says design. And I think it's really important for people to understand that difference. It's key. It's one of the reasons the regulations say, you can't just go after a project because you don't like the density. There's got to be some tangible reason ensconced in these local concerns that are on the screen right now. Open space is typically it could be an adverse impact on a piece of open space that's in a town's open space plan, has been there forever. But often what open space actually means in the context of 40B permitting is whether there is a decent open space treatment on the site. Does the site provide for open space and recreation amenities for the residents in the development? Planning is kind of a stretch, but it's essentially, if you build affordable housing on this site, does this somehow frustrate in a way that it just can't be remediated on a planning concern of the town? When in the rare cases where this has actually been argued successfully, it might be something, for example, where a community has done a master plan for economic development and has zoned a certain area for economic growth and has done something about affordable housing in other parts of the community. And I just want to really underscore this. The Housing Appeals Committee and the courts do not care about a plan unless the town has actually planned for housing and done something about it. It's just absolutely critical to understand this. So if you have a recent master plan, you say, well, our master plan doesn't recognize that area for affordable housing. It's zoned for single family, or it's zoned for industrial, or whatever. And that plan doesn't say anything about affordable housing. And then also has not actually led to the production of affordable housing. Typically, the planning argument falls on its face.
And I'm just going to add one other thing about this list of local concerns. And Judy, you may have different experience than I do, but having looked at a lot of HAC cases and a lot of court cases reviewing HAC decisions, the practical reality is that even though these things are all listed as local concerns under 40B, the ones that really matter to the HAC if a decision goes up on appeal are health, safety, and maybe environmental.
That's correct.
Ultimately, when the HAC is reviewing a ZBA decision, it does not care about design. It does not care about aesthetics. It cares very little, if at all, about open space, with the exception of the example that Judy just gave, where there is an actual plan that, for example, designates this area as industrial, but someplace else is, committed to production of affordable housing. These things don't matter. It's health, safety, and environmental. And I know that when I'm sitting on the ZBA on a 40B panel, those are the things that I am most mindful of because I'm aware of what the case law says.
And I have to tell you, she's absolutely right. And it frustrates me no end because I still think the statute does not discriminate against these. But the reality of the case law is that it's those top three items that.
It is
that would-
frustrating because it basically means that the HAC and the courts have read out of the regulations
Right.
these other defined local concerns. And I'm not saying that they don't exist on the books, but I'm just saying as a practical matter, you're very hard pressed to find an instance where the HAC would uphold a board decision that was made based on design, planning, open space, or other local concerns.
Right. Right. Okay. Oops. So the board really has three options when it gets to the end of the hearing process. And it has all the information it needs. There's no more need for testimony or documentation. The record is complete. Now they have to make a decision. They can either deny it, which is a not the preferred way to go, but sometimes there is no choice. Approval with conditions or approval as is. I don't think I've ever seen a 40B approved as is. Usually what happens is it's approved with conditions. There's a huge difference between the two. The denial is really if the developer appeals because you denied the matter, the sole thing that the Housing Appeals Committee is really focusing on is where are you relative to that 10%. Whereas approval with conditions is really more, it's more of a look at the validity of the conditions themselves and the relative impacts that they have on the project. So in terms of the standard, if you will, of the hearing, it is different between a denial and approval with conditions. And it's why generally, even when a board is concerned about a project, the advice will be approve it with conditions and let the chips fall where they may, because a denial is so much harder to sustain.
Right. And I think, the important caveat, though, about any conditions in a decision is that they cannot make the project uneconomic, right? And, for purposes of 40B, uneconomic basically means that the developer won't realize a reasonable return on the project. And that's a little bit squishy and nebulous and defined in some DHCD guidelines. But I think as a practical matter, when you're a board and you're looking at these things, when you think about mitigation measures that you might include in a condition decision, you can't impose on a 40B project any requirements, with respect to incurring costs of public improvements or offsite infrastructure that you would not otherwise impose on unsubsidized housing. You also can't ask a 40B developer to do anything to mitigate a pre-existing condition. If an intersection was already at a level of service F, you can't ask that a 40B developer bring it up to a level of service C or A or whatever. And you can't ask them to mitigate impacts that are not theirs, or mitigate more than the impacts that they're causing to the town.
Yes. One of the cases I was involved with a few years back with a ZBA, the neighborhood gave very credible testimony about how unsafe it was to walk down their street. I mean, they talked at length about how unsafe it was to walk down the street. And the developer's attorney, whether you like it or not, said, well, why hasn't the town done something about it? That it's not really the developer's problem to fix the fact that your street is already unsafe. So people need to be careful what they ask for in these proceedings. But to get to the appeal process, and this is where that are you over or under 10% is really so key. If the applicant is unhappy with the board's decision and the town is under 10%, the applicant can appeal to the Housing Appeals Committee. Otherwise, and other parties go to Superior Court or Land Court. If you're over 10%, that remedy of going to the Housing Appeals Committee is no longer available. So this is just kind of a chart that Johanna did, which is great. It's kind of trying to look at the whole picture here of what the responsibilities are of different people at different, points in the process. So subsidizing agency is in charge of project eligibility, handles this process called final approval after the comprehensive permit's granted. I have a slide on that in a little bit. And then the monitoring for ongoing compliance with the affordable housing restriction. And also, of course, monitoring just, is the project being maintained? Is it in good shape? How are the financials working on this? There's a management oversight as well. The select board is responsible for what happens with the project eligibility process from the town's perspective, providing comments to the subsidizing agency. And then during the permit process, of course, making sure that the town departments are providing whatever the ZBA needs in terms of support to go through the permitting process. So making sure that your departments understand their job is to help the Board of Appeals, not to take an advocacy position, but simply to help the ZBA, which I'm sure that is a message that you folks would give. Town departments' role is to comment on technical issues that are within the ZBA's purview, to facilitate the peer review process, which Tim has been helpful on in the last few days. It's been great. Participating in work sessions with the developer if the ZBA asks them to. Work sessions are not always done in town. Sometimes they are, sometimes they're not. It's really up to the ZBA to decide whether they want town staff to meet with the developer outside the hearing process, to discuss some details about, the stormwater system or whatever. But it would be always sort of those kinds of details. And then helping the ZBA kind of manage the documentation process for the public hearing. The board's job, of course, is to conduct the public hearing and do the technical review, get feedback from peer reviewers, solicit comments at the hearing, run a fair hearing process, which they are more than capable of doing, and then reaching a decision in which they weigh regional housing needs against those local concerns and prepare and vote on a decision and make sure it's filed timely with the town clerk. After the comprehensive permit process, the subsidizing agency gets active again. It goes through what's called the final approval process. There is a regulatory agreement that needs to be executed and recorded with the Registry of Deeds that establishes the affordable housing restriction and how it's going to be monitored, what the income limits will be, how all of that's going to, to be handled and reported over time. There will be an affirmative fair housing marketing plan that the subsidizing agency requires to make sure that the units are available on a fair and open basis to anybody who is eligible to buy or rent a unit. And then making sure that the limited dividend restriction is actually completed and that a final cost certification is prepared when the project is done. Once the project goes under construction, of course, the town departments have inspectional responsibilities, permitting responsibilities at the departmental level. The cost certification report will be provided to the town for review and comment, but not for a decision. And then sometimes, I would say often, Johanna, I'm not sure what your experience is on this, but changes to a comprehensive permit happen all the time in my experience. And a lot of it is because the plans that are filed at the beginning of the process are so preliminary. And a lot of kind of, site investigation that probably should have been done hasn't been done. Once the developer has the permit and now they're ready to sort of move to the next level of investment in the project, suddenly they find out there's ledge on the site. So it's not uncommon for an applicant to have to come back to a ZBA and say, I need an amendment to my permit. And if it's a minor change that's essentially consistent with the original decision, it's handled administratively. If it's more than that, then it can cause the ZBA to reopen the public hearing process, but only for the matter involving the change to the permit. So it's not reopening the whole case.
And there's some pretty helpful guidance actually within the regulations about what constitutes a substantial or an insubstantial change. And so when the ZBA is looking at what the applicant is proposing to change, there's almost a checklist, does it fit into this? Does it fit into this? And if it fits into any of those boxes, which it very often does, it is an insubstantial change. And then it's, deemed approved essentially.
Right. So just to kind of bring this to a close, there are some fair housing issues I want to just let you folks be aware of, and why they've become such an issue with 40B over the last decade. Fair housing comes into play with these projects because not only do units that are affordable have to be affordable, but they have to be made available to anybody within basically the same labor market area who may be eligible for units. So there has to be an outreach process beyond the community to make people aware of an opportunity to buy or rent a unit in Milton. So there's an affirmative fair housing marketing plan that is prepared by typically a consultant to the developer and reviewed and approved by the subsidizing agency that says, now you can start marketing these units. Here's how the lottery is going to work. There will be a lottery. People are selected, based on a lottery system. Local preference, so-called, may be allowed. It is no longer guaranteed. I've actually not seen it be turned down, but communities do have to request it. It's not a problem of the Board of Appeals. It's really more the select board or the Affordable Housing Committee or somebody, at some point is going to be in contact with the developer. The developer is going to ask, do you want local preference? If you do, then you have to make an argument for it. And so the way local preference typically works is that if you adopt you have to adopt the state's categories for local preference. You can't make up your own. It's essentially someone who lives in Milton now. Doesn't matter how long they've lived there, but are they a resident? Do they work for the town? Do they work for a local business? Or do they have children in the local schools, but the family doesn't live in Milton? So those are the allowable local preference categories. You can ask to have local preference. And what that means is that when the lottery process is conducted, people who fall in those local preference categories would get the first opportunity for some percentage of the affordable units. The maximum local preference is typically 70%. It's important to remember, despite all of that, just to keep in mind that Chapter 40B exists to address regional needs and regional disparities in meeting those needs. So it's not an accident that the Federal Fair Housing Act passed on April 11th, 1968, and Chapter 40B passed the following year in the fall. It's just not an accident. There was such a vibrant and frankly very difficult and strained conversation about race in this country in the late 1960s. I often laugh when younger people ask me what it was like to be a hippie, and they have absolutely no idea how riveted this country was with racial strife in the 1960s. It was horrendous. So these things all happened for a reason. Chapter 40B is sort of functioning as a check on local requirements that might make affordable housing infeasible to build in one community or another, such that equality of opportunity, or equity rather, is really the more important concept, whether there's a denial of equity or an imbalance in equity within communities within a region. So the state has, over time, especially in the last 7 to 8 years, adopted some fair housing policies that come to bear on Chapter 40B, and actually even on your own local regulations that you should be aware of. So there is this document called an analysis of impediments. It was recently updated, but the sort of big update was done in 2013. And that update has a lot to do with some of the things that you hear about now, with requirements or limitations that are placed on Chapter 40B developments. And so one of the findings that came out of the 2013 plan was that this quote that's on the screen: there was widespread barriers to multifamily housing. Townhomes and single-family homes on the small lots and accessory apartments. In other words, supply was constrained. And what can we do about supply? So that was one of the findings, which I don't think is a big surprise, that came out of the 2013 analysis of impediments. Another one was there are age-restricted developments everywhere, and they're not producing housing for younger families. And this was true not only of zoning, but frankly, even Chapter 40B developments. It was rampant in the early 2000s that 40B developments were being approved with restrictions on bedrooms, and the subsidizing agencies didn't do anything about it. So we were not building housing for families. And so the gap for family housing increased. And so in the analysis of impediments, the state said our own programs are perpetuating this problem. In addition to cities and towns wanting to kind of promote age restrictions, we're doing it too. And as a result, we're not building family housing. And yet families are the ones with the greatest housing needs. So out of these kind of findings from the AI came some policies that affect Chapter 40B and also local zoning. And one is that age-restricted housing was not going to be approved as much as part of the Chapter 40B process. There also, by the way, was a concern that some markets were becoming saturated with over 55 housing. So the state said, okay, we're not going to just approve subsidized affordable over 55 housing developments anymore. We're really going to scrutinize the market, and we're going to look at what's been done in this particular community to create family housing. And if there hasn't been anything done about family housing and it's all been age restricted, we're not going to approve more age restricted developments. So this was sort of a policy that was embraced by DHCD. Another one that's more recent was that DHCD has said in so-called friendly Chapter 40B developments that are essentially negotiated by the town and the developer under what's called the local initiative program, we're not going to count those units on the subsidized housing inventory if the age restriction bars children under 18 from living in the development. So you can have an age restriction. Federal Fair Housing Act does provide for age-restricted housing, but you can't deny occupancy to someone who's under 18. We have children living with grandparents. We have people getting married at older ages. We have second marriages. We have households who are 55, 56, 57 with young children who are barred from age-restricted housing simply because of a child. So we're not going to allow that anymore. So that was another kind of policy outcome from the analysis of impediments. And you may hear something about this. So just be aware, folks, when you write zoning for age-restricted housing, you have to make sure that you're not barring people who are under 18 because the affordable units won't count. There's also, in furtherance of the need for addressing family housing, another policy response that came out of the analysis of impediments was we're not going to grant we're not going to grant project eligibility anymore, and boards of appeal aren't going to grant comprehensive permits anymore that don't include some family housing. And that's why you often hear now about the so-called 10% standard for 3-bedroom units. It is now a policy. So it's basically, told the developers, don't bother negotiating with the local officials to get rid of them because you're not going to make it through final approval. There has to be 3-bedroom units. So that is now a policy stance. I think everybody's kind of used to it at this point, but it's fairly new in the lifeline of Chapter 40B, which, mind you, passed in 1969. The insistence on providing some family housing is a fairly recent thing. Another aspect of this is that the Attorney General, which you're probably all aware, has a review responsibility or review authority for local zoning, has begun to look at zoning bylaws that are being passed for whether they contain potential barriers to housing for families. And the reason that you need to know about this is that if you have a policy like inclusionary zoning, you need to make sure that the inclusionary zoning units don't somehow end up, in a review process with the AG where they may be, subject to review. Recently, the Attorney General has made comments to a number of communities where, for the most part, bedroom restrictions were written into local zoning. The AG is not denying these zoning bylaws. They're simply pointing out to communities you could have a problem. And so this is just a list that's the most recent ones I was able to find, doing a quick look in the Municipal Law Unit's website of communities that have been put on notice. When you restrict bedrooms, the number of bedrooms in a unit, you may in fact be violating the Federal Fair Housing Act. So where it comes together with Chapter 40B is just being aware of the impact that a bedroom restriction can have on whether units that are affordable under your zoning bylaw may or may not count. That's the reason I'm bringing this up. I think that's it. God, Johanna, we got through this. Pretty good.
I'm amazed. The time to spare, even.
I know.
So simple, right?
Right.
So we're happy to take any questions that board members may have. We realize it's a lot to process.
Does anyone have questions from the board?
Yes, can you hear me? This is Arthur Doyle from the Select Board.
Yes,
Hi.
I can hear you.
Thank you very much. We appreciate this. And I was wondering if you could make the PowerPoint available.
Oh, sure.
Absolutely.
Thank you.
Yep.
That would be very helpful. Appreciate it.
This has been recorded, so people will be able to make use of this whenever they like. It will go up on the MATV website, and we'll put the presentation up as well, hopefully with a link, so you can go right to this recording. Thank you both so much. And I'm just looking to make sure. I can't see all the board members in a row, but I don't see anyone with a hand up.
Madam
It is
Chair, I
hard
don't,
with-
oh, go ahead, Mike.
No, Mike, Katie, I think Mike said he doesn't have anything.
Oh, okay. I was just saying the same thing, that I don't have anything either in terms of questions, but thank you, Johanna, and thank you, Judy, for a very good review of 40B and a lot of information. And we have a lot of people on the call tonight, so I think this will be helpful for a lot of our residents who are impacted by 40B or who are just generally curious about it. There's a lot of interest in town, given all the applications that we have and pending or on their way to be pending before the ZBA. So thank you for this information. This was very good.
Thank you.
Well, I don't have really a specific question, but I know you've both done trainings for other communities, and I know Judy, you were just at CHAPA and leading some of the conference, which I thought was excellent.
Thank
And
you.
for people who don't know what CHAPA is, that's the Citizens Housing and Planning Association, and they have a wonderful website with all kinds of resources. So you might want to check that out. But I suppose one of my general questions is, what do you see that really trips up communities the most? And I don't know if you want to split it into sort of our select board role versus the ZBA's role, or something else. You have so much experience in this. I'm not sure how to phrase that question.
Well, I'll jump in with a quick answer while Judy is thinking and drawing on her wealth of experience. But I think that it's really important that the town conduct a consistent process. So first of all, the select board, the town department, the ZBA should all treat a 40, even though it's a little bit different in terms of what the scope of the ZBA's review is, you should still run it as a permit process as you would any other development. So, basically, it's like a more extensive site plan or special permit type review. And so if there are things that the select board does in the course of a 40A project, it can do it with respect to a 40B project. But if you don't normally do something on a 40A project, you probably ought not to do it on a 40B project. I think the other thing that's really important is that obviously each one of the 40B proposals is different. There are different neighborhood concerns, there are different impacts, there are different scopes of the project, but the projects need to be reviewed and processed across different ZBAs, different ZBA panels in a consistent fashion. There shouldn't be one hearing where, you're calling in experts from I'm not sure where, but in 3 others you're not. There needs to be a basic agreement on here's how we're going to run the process. One of the things that you don't want is, for any one particular developer or project to say, we were singled out, we were treated differently.
Right.
The best way to ensure that things go smoothly is to have a consistent process across panels and across projects.
Thank you. Judy, that
Madam
seemed
Chair.
to be your sort of same thing. Okay, great. And Richard, did you have something? A
I
question?
just had one comment to Joanna's remarks, is that, clearly absent 40B, I think we all aware that any proposal of these nature, particularly 2 that we're looking at right now, Canton Ave and Boohol Ave, wouldn't even be on the table for discussion. I remember years ago, there was a shopping mall that was proposed for the DPW yard, and in a very short period of time, that proposal ended because it was just so out of scope, and the response from all the neighborhoods that abutted it was just so overwhelmingly negative that it was removed. But I just want to touch on a little bit of the history here, and for both Judy and Joanna. You know, when 128 was built over 70 years ago, when this section of 128 came through Milton, the state decided at that time to carve out a portion, which we all know today is the Blue Hills Reservation. And that reservation encompasses over a third of our community, maybe even closer. I used to know exactly what it was, but it's been a long time since I've looked at it. But when the section came through Milton, you know, we didn't wind up with, you know, a South Shore Plaza as Braintree did, or Route 1 Auto Mile in Dedham. We preserved the greenery and the natural beauty of the Blue Hills Reservation for the region. And if you look at the neighborhoods that exist in Milton, if you look at Blue Hills Parkway, the entrance to Blue Hills Reservation from the city of Boston, which is used so much every day, 138, Chickatawba, all of that. And you look at the neighborhoods that abut them, they all kind of kept that character, that natural character to them. And even the projects that have taken place, Indian Cliff Estates, Quistic Brook, Fuller Village, even when you walk around our biggest employer in town, Curry College, who's added over 1,000 housing units since I first came to work for the town in the early 1980s. The character changed, and I hear Judy. You know, you talk. I've heard you use the word, and I'm not. It's not. I'm not arguing against density. I'm not arguing against affordable housing. But when you look at what's proposed here in just two of these proposals, Canton Ave and Blue, I mean, they're so out of character that anyone with common sense would come and you've done the sidewalks just as I have, would shake their head and say, how do you do this? You know, it's just, and I get the spirit of I get the letter of the law, but I don't believe the spirit of the law of 40B was written to do this. You talk about some of the positives of affordable housing, you know, public accommodation, being able to walk, public transit. There isn't any of those. There isn't even a bus route on these streets. I know perhaps I'm barking up a tree that I'm fighting a fight that's difficult to fight here, but it's true here. You know, I can't remember who the person was who gave this talk, and this was probably 20 years ago. I sat and listened to it. This was at an MAPC presentation when they talked about whoever developed 128, when they laid out that whole route, that when they preserved the Blue Hills and it definitely made the character of this community. And you know, if you or I or any elected politician wanted to take a quarter of an acre from the Blue Hills Reservation to use for any need other than its intended use today, there'd be World War III from the state. And I just think that this is really, you know, this isn't a 2-family or 6-family or 10-family or even a 20 units. These proposals are just so out of scope for where you want to put them. And I just don't see how we should not be allowed to have that argument as part of our argument. I said this to the resident. I don't care who's listening. I think if Governor Baker would have come and walk and see some of these, he would say to himself, he would say, what are we doing here? Even the most recent changes in legislation talk about putting affordable housing on public transit neighborhoods and locations. Well, those aren't here. So I'll leave you with that. It seems to me that, you know, somehow you have to be able to bring in the history of the community and how it was designed and how it retain the character it has. Not to say that you still don't have to work towards your affordable housing plan and getting to your 10%. And granted, I don't know how to do it overnight, but I just don't think this is the way, some of these proposals that are before us right now are the way to do it. So thank you for that, Madam Chair. I was way more long-winded than I ever intended to be, so thank you for that.
Thanks, Richard. I have another question, okay. So we were interrupted by COVID in trying to move our housing production plan forward, although we've continued to work on pieces of it. But I have a question because I've read the regulations and the statute and everything, but if we produce units, say we get our 48/50 units, I'm not sure what it is at this moment. The census is going to be released, and but if we get that and then we're in safe harbor, all of the applications that have already been filed with the ZBA still go forward. Is that correct? Okay, I just wanted to clear that up because I don't want to tell anyone the wrong thing, and that was my understanding. Thank you.
Yeah, the applications, the rights of the applicant are based on where the town is the day the applicant submits.
Right. Okay. Thank you. No one else has any questions? Well, I can't thank you all enough, and I very much appreciate too the review of the developments in fair housing legislation, because I think that it's difficult. Richard was speaking very eloquently about how our town developed. It's an old town. It has an actual meeting house. That our forebears ran the town from. So it is a really old community, and but we also know that zoning is restrictive. That's what it's meant to do. It's meant to control the use of land, and over time, sometimes it doesn't. It stops serving communities in a way that you end up with a law like 40B, which, as you both said, has transfers power, and in an effort to do something good, also results in some very big difficulties for communities. So we thank you both in guiding us through. It's a very consequential process for us and for the people who will end up moving into this housing, whether it be the market rate housing or the affordable units. Is there anything else that you'd like to say in conclusion, Judy and Johanna, before we adjourn?
I don't think so.
I don't think so. I mean, I do want to convey, both as someone who practices in this area and someone who has sat on the ZBA that has seen, and think in my tenure, over 20 40B projects. I absolutely recognize and appreciate what a challenging process this is for a town to negotiate. It's an enormous burden on all parts of the town, on the ZBA, on the select board, on the town departments. I want to give nothing but effusive praise for Tim, who is, working his heart out to make sure that this goes smoothly. But it's tough. It's a rough road. Getting to 10% is a big impact, and it's hard to do. But hopefully, the information and the perspective that we have provided tonight makes it at least a little bit clearer.
Yes, thank you.
Thank you.
Well,
Madam Chair, on that note, I want to pick up on what Johanna just said about Tim. I think we should also recognize our own board chair, Melinda Collins, because one of the issues that Melinda really campaigned on when she ran a few years ago was housing, and affordable housing in particular, I think. And having formed Melinda, you put forward the idea for the housing committee, and the housing committee's been meeting jointly with the Affordable Housing Trust. And that's made some good progress in the last couple of years. And I think it's built on some of the work of the master plan committee that the planning board really spearheaded a few years ago, several years ago now. And also that the master plan committee itself was spending almost 3 years working on the zoning for Milton Village. That's one area where we would like to see some mixed use multifamily projects put forward and proposed, rather than some of the locations that are being proposed. That's really an area of the town that we identified as being appropriate for family and mixed use developments. And we're hoping to extrapolate from there over to East Milton Square and the working group that Judy's working actively with. So there's been a lot of efforts in town by many people, including planning board members, members of this board, former members of this board and the planning board. And I think it's important that we recognize and that the residents understand that there's a lot of effort that's been going on for quite a number of years. Former planning director, a lot of staff at town hall and volunteers on different boards. And we have a terrific zoning board of appeals. We have some really good members on that board who have a lot of experience, and some newer members, but they're all quite busy right now and putting in a lot of time and effort. So hopefully the residents of the town will understand that there's a lot going on to address them, not only the pending applications, but to do some prospective planning.
Katie. Well said, as usual. Thank you. Well, with that, may I have a motion to adjourn?
So moved.
Thank you. And a second.
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 Thank you. Arthur, you're still muted. All those in favor, Ms. Conlon,
Yes.
Mr. Zulus,
Thank you, and thank you. Yes, and thank you to Judy and to Joanna.
Mr. Wells,
Thank you. Good night. Thank you both.
and
Yes, I'm sorry, yes.
no, that you said yes. Mr. Doyle.
Yes.
Thank you. Thank you, everyone, for who attended and who will watch in the future. Have a good evening.
Good night.
Good night.